Companies Act Section 183, Authority to make contributions to the National Defence Fund and other approved funds. 1. Introduction. National security and defence are matters of paramount importance for any country. To ensure adequate funding for defence-related initiatives, the Companies Act, under Section 183, grants companies the authority to make financial contributions to the National Defence Fund or any other fund designated by the central government for the purpose of national defence and security. This provision allows companies to contribute voluntarily without restrictions imposed by other sections of the Act that govern corporate financial decisions, charitable contributions, and political donations. The broad authority granted to companies under Section 183 reflects the government's recognition that corporate participation in national defence funding is a matter of national interest. The objectives of this section include: 1. Enabling companies to voluntarily contribute to national defence without financial or legal barriers. 2. Ensuring transparency by mandating disclosure of such contributions in financial statements. 3. Providing flexibility to the board of directors or other company authorities to approve contributions. 4. Recognizing the role of corporate social responsibility, CSR, in national security. This section overrides restrictions placed by Sections 180, 181, and 182, which impose limitations on corporate contributions for specific purposes. By granting unrestricted authority to contribute to defence-related funds, Section 183 highlights the importance of national security and corporate responsibility in supporting it. 2. Authority to approve contributions to the National Defence Fund. 2.1 Entities authorized to make contributions. Under Section 183, 1. Contributions to the National Defence Fund or any other government-approved defence fund may be made by the following. 1. The Board of Directors of the company. The Board of Directors is vested with the power to approve contributions without requiring shareholder approval or special resolutions. 2. Any person or authority exercising the powers of the Board. If the governance of a company is entrusted to an authority or person other than the Board, such an authority can approve the contribution. 3. The company in general meeting. The shareholders of a company, in a general meeting, may decide to contribute an amount for national defence purposes. These provisions ensure that contributions can be made swiftly and efficiently without procedural delays, recognizing the urgency and importance of defence-related funding. 2.2 Overriding effect on other provisions of the Act. A notable feature of Section 183 is that it overrides other restrictive provisions of the Companies Act. Contributions under this section are allowed notwithstanding any limitations set by Section 180, which governs restrictions on the Board's power to borrow and dispose of assets. Section 181, which sets conditions on corporate contributions to charitable and other funds. Section 182, which regulates corporate political donations. Any other provision of the Act, or the company's memorandum, articles of association, or any other governing document. By ensuring that contributions to national defence are not subject to financial or procedural constraints, Section 183 allows companies to play an active role in supporting the country's defence infrastructure without corporate governance restrictions. 3. Nature and scope of contributions under Section 183. 3.1 National Defence Fund and other approved funds. The primary beneficiary of contributions under Section 183 is the National Defence Fund, NDF. This is a government-established fund dedicated to supporting the armed forces by financing welfare programs, modern equipment, and critical infrastructure. Providing assistance to families of defence personnel in case of injury or fatality during service. Funding emergency defence needs during wartime or national security crisis. In addition to the National Defence Fund, the central government has the authority to approve other funds that qualify under this section. These may include Special Military Infrastructure Development Funds, funds established for war relief, disaster response, or defense modernization, funds aimed at technological advancement in defense and cyber security. 3.2 No limitations on the amount of contribution. Unlike other sections governing corporate donations, Section 183 imposes no upper limit on the amount a company can contribute to national defense. Companies have full discretion to determine the amount they wish to contribute based on their financial position and willingness to support national security efforts. This unrestricted financial contribution framework underscores the importance of corporate participation in strengthening national defense capabilities. 4. Disclosure requirements for contributions. 4.1 Mandatory financial disclosure in profit and loss account. To ensure transparency and accountability, Section 183(2) requires every company to disclose in its profit and loss account the total amount contributed during the financial year. This disclosure serves several key purposes. Maintaining financial transparency regarding corporate contributions to national defense. Allowing shareholders and stakeholders to assess the company's financial commitment to national causes. Ensuring compliance with accounting and audit standards by clearly recording contributions in financial statements. Preventing misuse of company funds under the pretext of national defense contributions. The disclosure must be clearly documented in the company's financial statements, specifying the total amount contributed during the financial year, the name of the fund to which the contribution was made, whether the contribution was a one-time payment or a recurring commitment. By making such disclosures mandatory, Section 183 ensures that corporate financial support for defense remains transparent and free from misrepresentation or fraudulent practices. 5. Corporate responsibility and national defense contributions. 5.1 Role of corporate social responsibility, CSR, in national security. Corporate contributions to national defense are often considered part of a company's corporate social responsibility, CSR, initiatives. Many companies actively support national causes, including defense funding, as part of their commitment to social responsibility. While Section 183 does not explicitly mandate such contributions under CSR, companies may voluntarily classify donations to the National Defense Fund as part of their CSR expenditure, provided such classification is in compliance with the CSR regulations outlined in the Companies Act and related rules. 5.2 Encouraging corporate participation in national defense initiatives. By removing financial restrictions and procedural obstacles, Section 183 actively encourages companies to contribute towards strengthening national security infrastructure, supporting defense personnel, and ensuring the country's preparedness for security challenges. Companies in sectors closely related to defense, such as aerospace and defense manufacturing, technology and cyber security, infrastructure and logistics, may find such contributions particularly relevant as part of their broader national security engagement. For more details, contact us.